For more insight on this is a labor analyst and founder of Creative Voodoo Consulting, Mamokgethi Molopyane. Thank you very much for joining us and good afternoon to you. Is there any legal ground to argue that Section 189(1) of the Labor Relations Act is unfair?
Not really. I mean, good afternoon, Colin, and to your viewers. When you look at how that section is drafted and put together, it's very clear that in terms of large-scale retrenchment, companies have to follow the rules that are put forward by the Labor Relations Act. And therefore, that would mean the company, in the case of Amcu, would have consulted first with the parties involved right from the top structure right to the bottom. And so that means unions were consulted and workers were consulted. If there was no unions in the case of this issue, or if Amcu was not a majority union, the fact that there has to have been workplace forum where employers and employees meet and discuss such issues. That means that the ruling indicates that indeed the company followed such and consulted trade unions. Probably there was a workplace forum, and so it deemed, the court deemed it fair that the company followed the procedures. As such, Amcu had no case to appeal.
So then, if all avenues have been explored before any legal action can be taken, and for the Labour Court to have this matter escalated to the Constitutional Court, do you think that if there wasn't any case to answer, then this could have just been a case to try and dilly-dally so that the jobs of the said employees should not be lost, and rather to just prolong the proceedings so that they can delay the retrenchment process?
Not really. I mean, when you look at the fact that the union followed the legal procedures of going through the Labour Court and various courts and right up until the Constitution Court, I think unions are always going to take under advice how do they appeal any ruling that is made and whether they should pursue it further in the interest of their workers, of their members or not. And in this case, the fact that it was previously dismissed by the Labour Court, I do think strategically the union could have arguably backed down from it, because when you look at the costs that are carried in pursuing this, it would mean now the union has to carry the cost of that. It's quite difficult to say that it would have been overturned. I do not see how it would have been overturned. However, as we know, unions are always going to say we carry out the mandate as per instructed by our members. Therefore, it is not just leaders who decide we are going to take this right to the Constitution Court, but if members are saying challenge this and see if you can challenge it and perhaps win it or have a ground to win it, go ahead. So arguably Amcu's leadership would have said that it is after consultative processes with their own members that they sought to pursue this further. However, when you look at the length of the processes, one wonders if it's really worth not just the litigation that is involved, but if it's really worth the effort to go right through the Constitution Court once the Labour Court has ruled on it. Of course, Colin, there has been cases or perhaps where one can say the ruling might have been different. But in this case, if the Section 189 one of the Labour Relations Act was followed and the Constitution Court is satisfied, I do not see how Amcu is going to come back from that other than accept this ruling. It's a tricky one in that sense that unions are always going to be saying we cannot just stop once one ruling is made by a Labour Court. We go back to our members, we tell them the results, or we tell them what has happened, the outcome, and the members must then direct us.
All right. Thank you very much for speaking to us. We are speaking live to Mamokgethi Molopyane, who is a labor analyst and Creative Voodoo Consulting.